Welcome to the Institution for Higher Learning in Common Law, where we train people not to be sheep. And now for your host, Professor Brad Parsons.
Thank you very much, Joseph.
All right.
Good evening. Quote, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb. Nor shall he be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation." Close quote. We're seeing some things happen now. I'm going away from the text here a little bit. When you talk about public danger, I feel that there is a real danger that our government is trying to create a situation where they can claim public danger. And this is worldwide. Look what just happened in France. We are importing ISIS terrorists into our country, allowing them in, and I think that this very well may erupt in some very drastic bloodshed, and when it does, the government very well may say, okay, we have public danger now, and start doing a lot of things that we don't want them to do. Anyway, that's just my opinion, and I throw it out there. Okay, the first thing, no person should be held to answer for a capital or otherwise infamous crime. This seems kind of clear, but what's an infamous crime? Black defines it as a crime which entails infamy upon one who has committed it. The term infamous, i.e., without fame or good report, was applied at common law to certain crimes upon conviction of which a person became incompetent to testify as a witness, upon the theory that a person would not commit so heinous a crime unless he was so depraved as to be unworthy of credit. These crimes are treason, felony, and crimen falsi. A crime punishable in the same state prison or penitentiary, with or without hard labor, is an infamous crime. With the provisions of the Fifth Amendment of the Constitution that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. It is not the character of the crime or the nature of but the nature of the punishment which renders the crime infamous. Whether a crime is infamous depends on the punishment which may be imposed therefore, not on the punishment which was imposed. Of import is that infamous attaches to a crime for which a punishment may be imposed in the state prison. It matters not that a plea bargain resulted in the imprisonment in the county jail or probation. The fact that the crime allowed for the punishment in state prison is all that's necessary for the crime to be infamous. Please take note that a grand jury may make a presentment or an indictment for lesser crimes, even misdemeanors, but that it is only required in a capital or otherwise infamous crime. Quote, "Unless on presentment or indictment of a grand jury." The only difference between a presentment and an indictment is its initiation. If the investigation and presentation of the allegations, evidence, etc., is initiated from without the grand jury, it's called an indictment. Today, it would be initiated by the district attorney or other prosecutor for the people, as I know of no state that allows for the bringing of charges to a grand jury by the people. And I'm going to break away from the text here. We have that right, but they have successfully convinced us that we don't have the right to do that, and they will physically try to keep us out away from the grand jury. On the other hand, if the charges result from an investigation initiated by the grand jury itself, it is a presentation. The result's the same. If a presentment or an indictment results from an investigation, it is presented to a court of competent jurisdiction for trial. Except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. The requirement for a presentment or indictment does not apply to the land or naval forces or the militia when in actual service in time of war or public danger. This is a little scary because the globalists are now creating incidents of public danger even as we speak. Countries, including this one, are importing ISIS members who then commit terrorist acts. Okay. Nor shall any person be subject for the same offense to be twice put in jeopardy of life and limb. This is the double jeopardy clause. It holds that you may not be tried for the same crime more than once after acquittal or conviction. However, there is a loophole built into this equation, and that is the term for the same crime. Now, most of the time people would think that we're talking about the same acts that have been done, and that's not the case. A person may be acquitted of a crime for committing an act that violates the criminal code and then retried for the same act under the guise of a different crime. A good example that I can remember personally was back in the 60s. There were, I think, 7 white men. I can't remember where, maybe Selma, Alabama, someplace like that in the South here, were acquitted for murdering civil rights workers and blacks, only to be retried again by the federal government for a different crime. And that crime was a violation of civil rights, which alleged the same exact act. Also keep in mind that this only comes into play after an acquittal or a conviction. A hung jury, which results in a mistrial, does not prevent a retrial on the same charge. Nor shall be compelled in any criminal case to be a witness against himself. The self-incrimination clause. The operative word here is incrimination. People can be made to testify against themselves and are routinely made to do so in civil trials. The protection begins the minute the focus of an investigation begins to gravitate toward you. Until that time, the investigator is treating you as a potential witness. But the minute he suspects that you may be a suspect, he must advise you of your rights under the Miranda versus Arizona decision, which tells you that 1, you have the right to remain silent. 2, you have the right to know that anything you say can and will be used against you in a court of law. That, if you choose to give up the right to remain silent, you have the right to have an attorney present while you're being questioned if you wish one. And 4, that if you cannot afford to hire an attorney, one will be appointed to represent you without charge. And then after that admonition, they will ask you, do you understand the rights that I've just advised you of? Do you wish to talk to me now? Notice that you're advised that anything you say can and will be used against you in a court of law The officer doesn't say it may be used or might be used. He says can and will, and he means that. Investigators are prone to give the admonition in a very nonchalant, bored manner, explaining that they have to do it, but it's just a formality. My advice is that when a police officer attempts to speak to you, you tell him that you don't answer questions. This holds true whether you are guilty of the act or not guilty of it. You are required by law to identify yourself, provide your address and date of birth, but that's it. Do not think that you are slick enough to lie to an investigator and outsmart him. If an investigator ever advises you of your rights, that means that he suspects you of evil doing. Immediately tell him that you wish to exercise your right to remain silent, and after identifying yourself, shut up. He may take you to jail, but if he does, he would have done so after interrogating you anyway. So you really haven't lost anything. By cooperating with him, you're not going to convince him he doesn't want to take you to jail. He may tell you that it will be better for you if you just admit to the crime. That if you do, he'll tell the judge that you were very cooperative. Yeah, right. As if the judge cares. If an investigator ever starts a tape recorder to question you, and after being unsuccessful in getting a confession, says that he's going to turn the tape recorder off and then does so, and then asks you, hey, just between the two of us here, there's no one else here, and you saw me shut the recorder off. Why did you do it? There's no one else here, and you can tell me. You take it to the bank that he has another tape recorder going on him someplace. Do not fall for it. In most states, it's a crime to lie to a law enforcement officer. It is not a crime for a law enforcement officer to lie to you, and they will do it repeatedly. They will tell you that they have your fingerprints, that they have other evidence, that they've got DNA evidence, that if you don't confess, they're going to convict you, and if you make them go to trial, you're going to get the full 20 years to life. But if you cop out now, we can cut that down to 10 to 20 or whatever. I don't know, and you don't know right now whether or not they've got DNA or fingerprints or eyewitness statements or whatever. What you do know, and I really want you to believe this, they do lie to you, they will lie to you, and chances are when they tell you that, they are lying through their teeth. Think about this. If they really had that evidence, why would they need your confession?